Bank, Jakarta. And then what they got from the main line was there's no such person. And even the name of another person was stated was no longer there at Standard Chartered Bank. And the bank never issued that kind of letter. So what happened then was that the financial advisor called for all parties meeting. So they all gathered together with the offeror and the legal counsel, and they make a call. The two numbers, the number that they were given the copy and the number that they have from the main line. To their horror, well, the number that was provided in the copy of the letter that the offeror gave, there was no answer. And when they called the main line, which was available on the net, they got the same answer as before, which says that there's no such person. And the bank didn't issue this particular letter. So what SIC said was that the financial advisor should have followed up with the legal advisor on the GMSLA, the Global Master Securities Lending Agreement, or sought confirmation from the legal advisor that the GMSLA was being reviewed. And as corporate finance professionals, the financial advisor should have been aware that it is common for legal and beneficial ownership to pass under a share lending agreement. So what they're trying to say that is for the standard of care, the duty of care that we require when we talk about takeover deals, it is not saying that, okay, I'm just a director or I'm just a professional of corporate finance. So, I left it to the lawyers or I left it to the financial advisors to actually give me that kind of confirmation. So if you extrapolate for what they're saying in this particular Technologies case, it also means that for directors in a takeover situation, they would actually have to be very, very cautious of whatever they signed on and be in touch when there's verification meetings, because this is not good enough to say that you delegated your responsibilities and hence you are absolved of it. It goes back to the same principles of directors' duties. Although a director is permitted to delegate certain duties, he still takes on the overall responsibility to act diligently and honestly. And when case laws have actually stated that if the circumstances gives rise to certain suspicion which a reasonable man would actually question further or investigate further, then they will actually expect that director to do the same as well. Okay, so this note is that there's this 2010 court case, the High Court judgment, where for this round, we could be said that the financial advisor managed to score back whatever they have lost during that 2010, because in the High Court judgment, what the judge says was that the court found that it was ultimately the offeror's repeated misrepresentation to OCBC that resulted in the collapse of the offer. And while the earlier SIC inquiry, which is that of the hearing committee, was directed at the breaches of the Securities Industry Council Code of Takeover, the court's action actually focuses on the precise extent of the wrongdoing of the offeror in terms of fraud and forgery. Okay, in terms of advisor, they actually said that the legal advisor is expected to cite the GMSLA in order to properly advise. Okay, what happened is, in this particular case, during the verification meeting, the offeror, Dr. So, he actually mentioned that he has entered into, because in verification meeting, whenever professionals are gathered in the room to verify a certain document, they will actually pose questions. So in the verification meeting, it transpired that Dr. So actually mentioned that he entered into a document, which is a Global Master Securities Lending Act, but he's not quite sure whether, about his rights, but he figured that, the share still belongs to him, although, so he actually made a disclosure during the verification meeting. And so in the verification meeting notes, it was actually stated, it's actually all in the 87-page hearing committee's decision. It's not from hearsay from my counterparts in the law firm. So the lawyer actually asked for a copy of the GMSNL, but then there were a little bit of to and from along the way, because the first time, the GMSLA's copy was given to the lawyers, they were missing pages. So the lawyer returned to them and said, okay, please come back to me with the whole entire copy, so on and so forth. So there was this to and fro. And then, so what was stated in the decision was that they didn't manage to cite it, and they didn't manage to follow up fully on its own accord to attain obtain the GMSLA for review as part of its own due diligence as legal advisor. And the council also emphasized that as corporate finance lawyers, they should have been aware that it's common for beneficial ownership to pass under a share lending agreement. But for the associate, there was this little twist that says that, well, it serves the spirit and objective of the code to ensure fair and equal treatment of all shareholders in a takeover. If the market is informed of the dealings by and identity of persons with significant holdings, so that the market may correctly assess and the changes of success or failure of a bid. It is a little bit in debate whether the findings of the SIC was actually correct at that time or not, because if you follow the timeline, it is actually after that Opus managed to, Opus fell down, and then the creditors took over the ownership of the shares. And then it's during this window period, before this information is made publicly available, that there was certain trading by the associate of those shares. In terms of SIC's ruling for order of compensation with respect to the associate, its view was, well, it's not appropriate to make an offer, because the rationale is that when a compensation is appropriate when there is a breach of an obligation to make an offer on the terms prescribed by the code. So they're making a distinction between if you have an obligation to make an offer and you breach it, then we will accord compensation. But otherwise, well, it's not within that realm of the analysis of the breaches of the code to say whether the other parties concerned would actually have to make compensation to the shareholders. So if shareholders are looking at it, then you're talking about civil actions, so on and so forth, under common law, and not so much, and the Securities Futures Act, and not so much about whether the SIC which actually stepped in when, from this case. But of course, usually with the development cases, even the ruling of the SIC is actually not that of a court case. But in this particular case, that was the position that the hearing committee actually took. Okay, as I said, in between my presentations, there were certain other legal concerns because we did an analysis for one of the clients which wanted to pursue action. Well, there were certain breaches of the code on the takeovers, breaches of your Securities Futures Act, disclosure of a shareholder's interest, shareholding, breaches of your Singapore Companies Act. That's actually regarding the directors. They wanted to see whether they can actually pursue action against the board of directors of JIC Technologies as well. Because they think that, you know, when the offeree or target company's board receives an offer, it should also exercise caution, judgment, and common sense. And then, of course, as we said before, there are breaches of common law duties, etc. Okay. Well, I think we're in time. The next little part that we'll cover in today's seminar is that on whistleblowing. Okay, in this, there's this, I think, if you've been following the newspaper, there's this recent AEM case judgment, which was that there was this former chief executive who actually blown a whistle against people in the board, which included the CFO and the chairman of AEM, and then there was certain reported to, and then the matter actually went up to the regulators, and what happens was, because of his act of whistleblowing, somehow his sentence was mitigated to that of just a fine of $200,000 and a disqualification to act as a director of a company. So that was what comes up in that particular sense. When we talk about whistleblowing for today, it's just an aspect of a very minor aspect of corporate governance, because when we talk about corporate governance, it's about processes, systems, risk management, internal controls, audit. These days, the buzzwords is actually risk management. But for today's topic, we actually talk about whistleblowing. We would like to share with you one of the case which we have handled some time ago, and how the audit committee actually went about in investigating the whistleblower case. Because as we do acknowledge that the guidebook, the ACGC guidebook, is actually a very, very comprehensive book that was issued in 2009. I think there's this little thing that we would like to bring to your attention about what actually happens in practice. Well, as lawyers, as I said before, we'll always go back to your sources of law, your regulatory requirements and guidelines. Listing Rule 719 talks about the irregularities and fraud. Like if the audit committee is aware of any suspected fraud or irregularity or suspected infringement of any Singapore laws or regulations or rules of the exchange or any other regulatory authority in Singapore, which has or is likely to have a material impact on the issuer's operating results or financial position, then the AC must discuss such matters with the external auditors and at an appropriate time report the matter to the board. Okay, note that it is not any other little breaches that you find under the Companies Act, but that which is material impact on the issuer's operating results or financial position. Then we talk about the code, guideline 11.7. In this case, we're talking about the 2005 Code of Corporate Governance. It talks about the fact that the requirement that your AC should review arrangements by which the staff of the company may in confidence raise concerns. If you look back to your ACGC guidebook, there is actually a sample of how a whistleblowing protocol or handbook should look like and some of the main points. Okay, Singapore position again, we talk about the code, we talk about the guidebook, we talk about this corruption, drug trafficking and other serious crimes. There's actually certain mitigating exemptions that are accorded to for people who whistleblow. Same thing goes for your Competition Commission, the leniency program, and then the code of conduct issued by the Association of Banks. Well, in Singapore, as of now, we do not have any protection for whistleblowing. Unlike UK or US, this position was actually debated before in the Parliament a few years back, whether we should or should not have a whistleblowing law. So the position that the government took was very simple. At that point in time, it was when Sarbanes-Oxley came out after the Enron and WorldCom's collapse. So the government thinks that there are other sufficient safeguards and measures to protect whistleblowers. Okay, and there are laws that protects confidentiality. And so they would rather leave it to play for that moment because it's still a ways to see what happens. So what we took was a wait and see stance. Just like how the code was evolved in 2001, there were many types of approaches worldwide actually. Like Sarbanes-Oxley, that's a very mandatory approach. It's do it or you get criminal sanctions. For those of you who are familiar with the negative assurance, you will note that under our listing manual, negative assurance is as simple as two directors signing off for and on behalf of the board of directors to say that nothing material has come to their attention which will affect their financial statements. But if you compare that to that of Sarbanes-Oxley, you would find that the same requirement is actually imposed on the chief financial officer and the director. And if they sign off, criminal penalties and sanctions actually apply if they are found to be in breach. So it's very, very different. It's still a ways to see what happens if you breach that rule per se. But one thing that comes up is that for every breach of the listing rule, which connects to that of disclosure requirements, always bear in mind that of Section 203 of your Securities Futures Act, because that is the one that gives teeth to what happens. For instance, in the Track 2000 case, even though after the SGX reprimanded the Track 2000 for having not made prompt and timely disclosure on the SGXnet concurrently to all the shareholders in breach of Chapter 7, MAS actually followed up on the basis of Section 203 of the Securities Futures Act on disclosure and slapped them with a fine for that breach of disclosure requirement under the listing rule. Okay, when faced with the whistleblowing situation, there are actually quite a number of practical considerations that we talk about, like what are the consequences if the audit committee or the board does not do anything upon the receipt of a whistleblowing complaint or does not handle it properly. We must understand that not all listed companies in Singapore are like, they have a very well-established system channels to actually look into each and every single complaint. So what happens? Do certain things get swept under the carpet? Yes, may or may not be, right? Because until and unless tested in court or someone whistleblowers and it blows up and you read it in newspaper articles or someone takes an action, you wouldn't actually know. So later on, I will just move on to talk about a 2000 case that we handled. At that point in time, it was actually disclosed in the SGXNet announcement in 2006, but I'm not so sure whether you can actually, it's still on the SGXNet online now. The company we're talking about was Fuyu, where the AC received an anonymous whistleblowing complaint that alleged that their chairperson had done certain things which were against the interests of the company. For instance, by setting up companies which compete with the listed company on the same sector of businesses, poaching their clients because the chairperson and his family members have access to confidential information. And then we had a full-blown whistleblowing investigation, which we'll show you the step paper in the later slides. Okay, and about the consequences if other parties take action. Because if something goes wrong and someone pursues, and it is found that it is of the negligence or omission of the audit committee or the board of directors, then certain consequences would definitely follow. Just like under the Companies Act, there is this concept of contributory negligence. For instance, if there's, for whatever reason, the financial statements were not correct, and then they sue the auditors in charge, there's actually a section in the Companies Act which auditors can use and say that there is contributory negligence on the part of the directors themselves. Okay, so it's not as easy as delegation and that's the end of the story. Then exposure of the AC, like what I say, that concept, or the board is when the whistleblowing policy is not in place or implemented correctly. The current position in Singapore is that under the 2005 code, the AC's responsibility is to implement and establish that whistleblowing policy. It is only introduced in the 2005 code and not found in the previous, its predecessor, the 2001 code. And then there's this board's reservations of all legal rights against malicious or untrue allegations, as in the note on the 2009 case was also a matter which we help clients in. Well, in that particular whistleblowing is the predecessor known as Global Area. The financial officer who actually resigned, he set out a number of multiple pages because now there's this cessation template that people have to fill in, right, when they resigned from the offices for key executives and that of the board of directors. And then later there were certain investigations found, and they actually found that some of the allegations were not true in an exaggerated manner. True, the system of the company is not perfect in terms of internal controls and risk management, but on a bigger level, on a larger picture, well, it is a little bit common that for certain companies, things are not perfect. That's why they have internal auditors who go in, propose a few cycles of how they would do a management paper, find the weaknesses, and propose to the management on how to improvise the system. So, but largely, in that particular case, the Global Area case, most of the allegations were to an exaggerated extent and untrue. So then the board would actually, in their announcement, it did say that they will actually reserve all rights against that of the complainant or perpetuator. But the thing is, like in all things in litigation, the deep pocket theory. If your opponent doesn't really have a deep pocket, then it's actually of no use to pursue a litigation action unless you want to declare him bankrupt. But what good does it do for you? For a listed company, from their point of view, that announcements have to be made when you're talking about litigation, and then there will be maybe certain movements in shareholding prices and everything until the day that you get a judgment in your favor. Well, the company actually has to look at the larger picture of business operations. Okay, so this one is what we talk about, basis of power. When faced with a whistleblowing complaint, certain people are a little bit lost where they should refer to, how do they draw their powers, Is this within their scope of jurisdiction? Is this within their powers? Well, the very first place that an AC should look at is their terms of reference, what they can actually do. It actually lays out what they can actually do in each particular step. And then their own company's whistleblowing policy. Okay, step one is as easy as, well, we're talking about the implementation, which is actually very standard. There will be this proposed whistleblowing policy, which is submitted to the board for consideration. And then there was this board approval, followed by implementation, and then circulation to existing and new employees. Okay, in that particular case, in 2006, we actually derived a mind map for the audit committee of each and every step they would go through upon receipt of that complaint. Because it's something new to the board, and it's not every day that you get a complaint. So, well, it starts with receipt of complaint from the AC. And then the AC will review the contents. And then next step is to make a preliminary determination or commence initial inquiries on the letter, because you can't just react on every single complaint. Sometimes it could be just malicious, but sometimes it can be true. So it comes to a point where you talk about discretion, exercising judgment. So in that particular case, at the determination stage, you would have, well, two scenarios. One, when there's sufficient information to raise reasonable doubts. Or two, the committee actually rejects and stops there. Okay, which means that when at that stage of preliminary determination, the very few steps is first, they will look at the contents of the letter. And if the whistleblower actually states his name, they will actually call in the whistleblower for an interview to ask more questions, more information as to how and why and the basis of that. And usually sometimes the whistleblower would actually have certain information as to, they actually talk to certain suppliers and this is what they're understanding, or they have done company searches to find that there is this particular company registered in the name of the relative of the chairman, and it is in that context. Then you proceed on to engage professionals for private investigations. You seek legal and or expert advice, and then you have to inform the complainant. It's actually very usual in the whistleblowing policy to say that in any case, the audit committee has a duty to inform the complainant whether they would proceed or not proceed with the investigations upon receipt of a whistleblowing letter. So that is on the right-hand side, is that if you proceed. On the left-hand side, it just stops there. It just says that, okay, no further investigations is required, and then the AC will just report to the board that, okay, they have received this complaint, and then they notify the complainant that no action taken, and they will actually explain in the letter as to why, if the complainant can be reached. It's not as anonymous as X, and they can't go back to the complainant. What it is that in the whistleblowing policies, it states that the identity of the complainant should always be kept confidential, albeit that we do not have whistleblowing protection laws in Singapore. Okay, so then we talk about the scenario, because that is case closed, right? What if case opens and you need to walk through the stages of the game plan? Well, if you actually think that the AC, the audit committee, actually makes a decision based on the circumstantial factors, the information they have, the initial public searches they conduct, and the interviews that they could possibly get hold of with persons concerned, while not alerting the person who was being complained, they will actually conduct investigations, which usually take about 2 to 4 weeks. In this particular case, they would usually engage private investigators. So in the case that we handled in 2006, it was about a competing business in Dongguan. So what we did was the private investigators were sent down to Dongguan in China to speak to the suppliers, and then they actually go to the competitor business set up and dressed up as people who are interested in giving a particular order to the manufacturing plant to get certain information about operations, and then they talk to certain people in that area in the same business, the suppliers, the customers, to find out more, and then they came out with a report as to whether the chairman in that particular case actually had set up a competing business which was going against the interests of the company. So after the investigations were conducted, at the same time, the committee will actually deliberate on the findings. And at the same time, when they're doing these investigations, they would concurrently be providing us, the legal counsel, with whatever they have at each stage. So at every stage when there's new evidence, we actually do a report, a preliminary report to the audit committee to tell them, okay, what are the breaches of this particular chairman, for instance, under the Companies Act, director's duties. Disclosure of interest in competing business is one, right? And then that of disclosure of interest in competing business is actually found in your listing rules for listed companies. But for that, in Companies Act, it's actually not found. But in that particular case, what happened was the listed company actually also entered into certain contractual business transactions with the setup which was established by the chairman and his family members. So there's this interested transaction factor, and that was not disclosed of Chapter 9, for instance. And even if it doesn't cross the threshold, it is the director's duty to make full and frank disclosure to the rest of the board and make sure that it's documented down in the register of IPT, Interested Person Transaction. So that was breached in that particular case. And so after the committee deliberate, as usual, they will report to the board for further deliberation. Well, at that point in time, when they discovered that, okay, something is wrong and we have evidence but not sufficient evidence, so what should we do? They actually were thinking between internal disciplinary actions, dismissal, and all the report to CAD, SGX, and other relevant authorities. Well, in that particular case, for a moment, there were a lot of considerations as to what they should do next, because they didn't want to do anything that unnecessarily affect the share market price. For a listed company, share market price movements, announcement of material information is very important. So there was a little to and fro, and then one of the questions put to us was, okay, what if I tell the chairperson to just resign and ask him to just make good whatever compensation that our company suffered? Can I just do that? That was the question posed to us. Because I just want my money back, I don't gain anything if he goes to jail, right? And with all these public announcements. Well, as lawyers, the answer is, no, you can't, because he actually breached the statutes. Of course, it would help to mitigate his case if he comes up voluntarily to compensate the company. But you can't just close it and sweep it under the carpet if you get the compensation in return, although it does help if the culprit actually volunteers to mitigate the position. Okay, very, very, very quickly, we're just talking about the elements, what there is, drawing your attention to what there is in the guidebook for audit committee in Singapore, elements of a good whistleblowing policy. As the slides will be made available to you, I think you could just take a quick look. And it's actually found in your ACGC guidebook, the annexes, on the good practices and what's a good audit, what's a brief checklist. This is actually more relevant to that of the audit committee. Okay, this hypothetical is actually is actually a rehash in a different form of the case that we handled. So what I wanted to draw your attention is that of the considerations of the audit committee at that point in time, like, okay, do I have the powers to handle this case? They have to consider legal issues such as, is there a crime committed? If so, is it a reportable offense? And then do you need to make an announcement just because of this? Or do you need to notify people? And then the problem with the problem with knowing that something is wrong and deciding whether you should announce at first instance is that there is this balance. How much do you disclose and how much is true? You need to verify before you put in anything in an announcement. And what if it's not true? What if then, as a backlash, you get a defamation suit, right? There's certain those considerations. And one of the things that was facing the AC that we advised was, should they just summon the chairperson and his family members for questioning? during investigation period, because when you alert someone, they might just do certain things to cover their tracks, or would it impede or undermine your efforts? So what we did in that particular case was, when we had all the evidence we needed, then we actually called for the chairperson, and then he called his own set of lawyers to explain himself, and then he subsequently resigned. And then there are also considerations as to credibility of the complaint. And then when do you actually ask for further facts and evidence? In the particular case, we also realized that there is certain limitations on what the AC can actually do, because when you're just a company, and the furthest you can go is having private investigations, you actually don't have the tools, the application tools and powers that of the regulators, who are able to do no seizure of computers, to do a computer forensic per se, or they could actually go further than that, because any further investigations would require expenses, more money on the part of the company. But then what is your end result? Would you actually be able to get redress for the company and adequate compensation? Or are you just wasting the time and expenses of the company? So in that case, what they did was they make a judgment. Once they have enough evidence, they caught the culprit and then asked for explanations, and then they alerted the Commercial Affairs Department. And then they leave it there, because for private companies, as I said, your application tools, your equipment and the expenses and the time and the money, it is not actually in your favor to expense everything just to catch a culprit when you have other issues, organizational issues to attend to. They were actually wanted to lean on that of the regulatory authorities, because if the regulatory authorities with their resources, they're able to convict someone, they can lean on that to pursue civil suits, let's say, per se, against the person. Or that would actually pressurize the culprit to do certain things to mitigate